Welcome, everyone. This is Jared Ambeau, owner of the Ambeau Law Firm and founder of Trial Alliance, and this is the issue number 38. Our topic for today is preparation is king. What does that mean? Well, so I just got out of this trial, this 2-week trial, and there's been a lot of publicity about it, the second-degree murder trial that we acquitted our client on. And the one thing I would say I owe that success to, that successful outcome, is preparation. Now, what does that mean? Well, I spend a tremendous amount of time preparing for trial. I spend time preparing by knowing the facts, knowing all the evidence, knowing the law, knowing the code of evidence, anticipating objections, anticipating the prosecution's witnesses, anticipating the prosecution theory, making my own theory, developing that theory. I mean, we go through so much stuff to prepare for our trial, for months, for years. Preparing our witness, preparing our defendant, talking to him, seeing if we can get him to be able to just take the stand and speak. I mean, for some people, that is a tremendously difficult thing to do. And for my particular client in this case, he's this very, very quiet, nerdy kid who's very socially awkward. It was incredibly difficult to get him to be able to even take the stand under cross-examination and speak in a way that was even slightly reasonable. And so it's very, very difficult. The whole matter is difficult. And one of the things I alluded to is important for me. It's something I told one of my associate, actually, that whenever I get ready to go to trial, I read the evidence code. I read the evidence practice manual. I used to have a set of flashcards, and I told him I lost them. I need to remake them because I constantly study the code of evidence. Well, for a lawyer, for a trial attorney, that is your toolbox. That's every weapon in my toolbox. That is the set of practical tools I use to try jury cases. You know, for a car salesman, it would be everything you know about the automobile, all of the information, right? But also all of the process, right? The code of evidence is kind of like knowing how financing works or how the car sales process itself works. What are the parameters of actually taking possession of this car and financing it with the finance guy? Like in a regular sales matter would be, you know, wouldn't be how much the product costs or what the information was about the product. It would be, how are we going to give the product to you? How are we going to deliver the product, and in what way, and in what condition the product's going to be in when it's delivered, and what are the processes of fixing it if you don't get enough product, or if you don't get the product you're looking for? I mean, the code of evidence is like the underlying fabric in which everything exists in a trial. It's the sort of operating fabric of the trial itself. And knowing the code of evidence is centrally important to being an effective trial attorney, right? And so in the midst of preparing for trial, in the midst of knowing all of the information, and in the midst of taking in all the facts, I concentrate and spend time understanding the fundamentals. Even 40 plus trials in, 10 years of law practice, hundreds and hundreds and hundreds of substantive hearings in court. And I'm still pick up the Code of Evidence practice manual before this trial and went through it and wrote down every Code of Evidence article I thought would be important in this matter. Every single one of them. And then I read the current case law on every single one of those. What's the current case law related to my particular issue? I know the definition of hearsay. I understand what it is. I'm trying to get this piece of evidence in it. It may have some hearsay in it. What are the exceptions, the exact exceptions? And what is the case law? What's the current case law say about those particular exceptions? So that if it comes up in a trial, I'm ready to argue it. If it comes up in a trial, I'm ready to make a record of arguing that. Even if I lose, I'm making the record. And for me, that's what makes a difference. It's preparation that makes a difference. It's preparation that makes me go from a good attorney to an exceptional attorney, is the manner in which I'm willing, the effort and energy I'm willing to put in prior to going to trial. So for me, preparation is king. And that's all I have today. Thank you for coming. This is going to start every day again. We're starting back on the issue every day again now that our trial's over. And I look forward to seeing you guys tomorrow. Have a wonderful evening. Thank you.